Hi everyone. Today we're going to be talking about psychologists in the legal system. So first I wanted to touch on the unit of analysis here. So the psychological approach focuses on the individual as the unit of analysis. And we know this. We know that psychologists look at human behavior, and psychologists try to make sense of human behavior in various contexts, such as the legal system. There are two other social sciences that might be interested in looking at the law and the legal system as well, and those would be anthropology and sociology. But in those disciplines, their emphasis tends to be on culture or society more broadly, rather than the individual. So they would look at how culture or society influences our law and the legal system. But as psychologists, we really are interested in this individual human as opposed to society more general. So before we really get started here, the first thing I wanted to do is just clear up some confusion that sometimes students have about the difference between these terms here. So the differences between psychologists, psychiatrists, and counselors. So first we have psychiatrists. And psychiatrists are individuals who have a medical degree, so they have an MD. And essentially, after they get their medical degree, or in the course of gaining their medical degree, they have some extra training in human behavior. So they're really primarily medical doctors that have this extra training in human behavior and psychology. Then we have psychologists, and psychologists can have either a PhD or a PsyD. And a PsyD is a professional degree. So in a PsyD, you're not expected to do research or have any formal dissertation or thesis. And obviously, if you're in a PsyD program, you're definitely in a clinical psychology program. There's no such thing as a PsyD program for experimental psychology. And this is in contrast to a PhD, where you would have a heavy focus on research. And a PhD can be either clinical or experimental. And a psychologist will typically have 5 to 7 years of post-baccalaureate training, and it really just depends on the specific discipline that you're going into. And kind of as I've touched on here, of course, psychologists can either be, clinical or experimental. And particularly myself, I'm training to be an experimental psychologist, so I really don't do any clinical work at all. I'm basically just strictly a researcher. And the last group that we have here is the counselor. And counselors usually have a master's degree, so an MA or an MS, but sometimes they do have a PhD. And counseling is slightly different from a psychologist, but they may do similar jobs, but they're really very, very clinically oriented in terms of treatment and treatment of individuals. So a counselor will have typically 2 to 3 years of post-baccalaureate training for the most part. Unless they have that PhD, that's going to be a longer time frame there. So I kind of just wanted to touch on those. Hopefully that clears up any confusion that you all might have had in terms of these terms. Next, I wanted to kind of look at the subfields that are relevant to psychology and law. So we're turning back strictly to a focus on psychology here, not psychiatry. So you're going to hear some different terms being used, and I just want to clear up any distinctions between these terms as well. So for example, we have forensic psychology. And forensic psychology refers to a very specific type of psychology and law. These are going to be clinical psychologists, and they do things like assess dangerousness of individuals. They do things like report to parole boards. Additionally, they might assess defendants for insanity at the time that they committed the crime. So they are very specific, specifically clinically oriented. Another type of or subdivision is when you have both a PhD and a JD. So in other words, you went to a joint psychology and law program. And coming out of these programs, again, as I mentioned, you would have both a PhD and a JD. So you have a law degree and you have a PhD in psychology. And there's really not many of these in the country. One of the biggest ones is actually at University of Nebraska-Lincoln. So the people coming out of that program there, they will have 2 degrees, the JD and the PhD. The next group is psychologists who are interested in the law. So this is psychology with law. And basically, these are psychologists that are interested in the law and the legal system, but they do not have a JD. They are studying legal issues, but through a psychological lens. And this is where I'm at. I'm in a psychology program, but I am studying legal issues through the psychological lens in that psychology program. We also have police psychologists, and these are psychologists that work directly within police departments, and they can assess officers after shootings, they can provide counseling, and therefore these psychologists will typically be clinical psychologists. And finally, we have correctional psychologists. And correctional psychologists are, as the name suggests, they work with inmates in correctional facilities such as jails or prisons. And again, these are also going to be clinical psychologists as opposed to experimental psychologists. So now you may run into these terms over the course of the semester, and so hopefully now you have an idea of kind of the distinctions and the differences between these. Next, I wanted to move on to how do psychologists interact with the legal system. So they interact with the legal system in many different ways and different roles. And the first of those being as a basic and applied researcher. And by the way, this is pretty much where I'm at this point. I consider myself a researcher in training. And what we do is we take the scientific method and we use it to answer legal questions. So questions like, under what conditions do eyewitnesses tend to make mistakes? Or how do jurors make decisions? Etc., etc. And some of the advantages of this, hopefully you will see throughout the course here, but really, there are many issues in the criminal justice system that psychologists have studied, and they've found better ways to do certain things. So I'd say a real advantage, of some of our work is that our research actually directly influences the legal system and can impact the system positively. However, some disadvantages come along with this. So sometimes the legal system actually misuses your research. So research always has its limitations, and research is done in specific ways. But people in the legal system might actually try to use your research or your work to their advantage, even when that's not the way that research was meant to be used or looked at. And then in terms of ethical issues, as a basic and applied researcher, you're bound by your research ethics. So sometimes we can't adequately study things in the legal system. So we try to study what's in the real world, but ethically, there are constraints on us. So for example, this might be something along the lines of looking at false confessions. And it turns out that people who confess to a crime that they didn't commit were often interrogated for a long time before confessing. But obviously, we can't subject people in our lab to 11 hours of intensive investigation just to see how false confession works. So we do have our limitations there. So we're going to be talking about contributions by researchers a lot throughout this course. But to begin, I just wanted to kind of mention a couple here. So one of the most important contributions that psycholegal researchers have made to the system involves eyewitness testimony and lineups. So we've actually become to understand the limitations of eyewitness memory and improve lineup identification. So there were methods being used by police departments all over the country, and these lineup methods tended to lead to errors. So after 25 years of research, we have now identified the problems in these lineups and figured out what solutions might improve these lineup procedures. Another area would be understanding the effects of suggestibility of children in the legal system. So there was this influx of children in the 80s that were alleging that they had been abused in daycares, but some of the interviews the children were exposed to were terribly misleading and coercive, and seemingly led to a number of false reports of abuse. So as psychologists and researchers, we figured out what was going on here, and we've also figured out better ways to interview children that we now use today instead. And then in the 90s, there was this increase in these repressed and recovered memories. And researchers were able to really discover therapeutic techniques that led to these false memories. So now, nowadays, clinicians don't use these techniques. So these are just very quickly some of the contributions that researchers have made to the legal system, and some of the things that we're going to be delving into and talking about throughout this course as this class goes on. The second way that psychologists can interact with the legal system is by serving as an expert witness. And expert witnesses possess special knowledge about a subject. And in some cases, the attorney will say, hey, we need an expert, either for the defense or the prosecution, but the judge is really the one that decides if the expert will be allowed. So the judge has the ultimate say. And what experts need to do is they need to provide information to the jury that is not available to a typical juror. So, for example, maybe the average person on the street doesn't realize all of the conditions that can make eyewitness identification faulty. So an expert needs to come in and basically educate the jury to these issues that they should keep in mind. So what an expert witness will do is they'll first identify their credentials, where they went to school, what degree, etc. And then the judge will turn to the opposing attorney and essentially ask if this person if they accept this person as an expert, and they typically say yes and do not object to this. And then the expert can go on and deliver their testimony. But as I mentioned, essentially what the expert is doing is they're educating the juror. So really the role of the expert witness is meant to be an impartial educator. You are not supposed to be partial to one side. You just present your research and educate the jury to that information. So you are not supposed to in any way suggest that the defendant might be guilty or not guilty. And of course, there are some ethical issues that come along with this as well. So while you are supposed to be impartial, but then again, you have been hired by one side. So you might be perceived as this, what we call the hired gun. And this essentially means that, this one side is paying you money, and if they're paying you enough money, you'll just essentially side with them. Give testimony that would benefit either the defense or the prosecution. So if you're the defense expert witness, essentially this is the notion that if the defense is paying you enough, you'll pretty much say whatever they want you to say. So most times when expert witnesses testify, they're asked pretty early on, how much are you getting paid? And if they're getting paid a whole lot of money, jurors may and do tend to discount some of the things that the expert is saying. So that brings us to, basically what can an expert say in these types of situations? So an expert witness's testimony must be based on legitimate scientific knowledge. So you cannot introduce junk science. But I do have to say that, some people do. This does happen. If the courts don't know that the science that you are presenting is quote-unquote junk science, then, you may be able to introduce something that is clearly not generally accepted in the field, but the court doesn't generally have knowledge of this. And when we're talking about whether or not something is considered junk science, what we use is what's known as the Daubert standard. And the Daubert standard suggests that science or research that expert witnesses present in court must be generally accepted within the relevant scientific community. And Daubert is the federal rule, and it's also used in some states. So essentially what this means is that the science must be, generally accepted in the field. Most other psychologists would have to agree with what this psychologist on the stand is saying. And that's what the essence of the Daubert standard is. But in order to catch this, in order for the court to catch this, legal players would have to kind of know that this is junk science or science that might not be generally accepted in the field. So there can be kind of some slippage there, as I've alluded to earlier. So the third way in which psychologists can interact with the legal system is as a policy evaluator. And what psychologists do here is they recommend and evaluate changes to the legal system, to policies related to the legal system. And there's various ethical concerns that come along with this as well, just like any of the other roles. So obviously, sometimes policymakers have their own agenda. So you may try to do the research and, the data comes out and the data suggests X, but these policymakers hired you and these policymakers want Y. And so they want you to, try to make Y come out in some way instead of X. So you really get some push and pull from people who are, making these statutes. But as a policy evaluator, psychologists in the role of a policy evaluator, you really, you have to stay true to what the data is telling you and what the research is suggesting. And the fourth role would be an advocate. So everyone that we've talked about so far is kind of supposed to be this impartial actor in the legal system. But this is not true of the advocate. What an advocate does is an advocate identifies with one side, so they're not assumed to be impartial. So, for example, the state of Wyoming has victim advocates. These individuals identify with one side, the victim. They're not concerned at all about the rights of the defendant and due process and things like that. And one type of advocate is the jury consultant. And the jury consultant, essentially what they do is they work with one side or another, and they try to help that one side that has hired them to put on the best possible case that they can put on. And jury consultants can be pro bono, or they can be paid, and most of the time, jury consultants are paid. And jury consultants are also mostly used in civil cases, and this is because jury consultants are extremely expensive. And most defendants don't have the kind of money that they would need in order to hire a jury consultant. In fact, it's really civil cases that have these corporations, civil cases that involve big corporations that really use these jury consultants. And that's because jury consultants can cost anywhere from $60,000 to $125,000. And as I've mentioned, essentially what the jury consultant does is they use this scientific method to try to tilt the case outcome in whatever side hired them, their favor. And of course there are ethical concerns with this as well. Some people say that this is kind of like rigging the jury and pushing their agenda. But if you think about it, it's really no different than what attorneys do, and what attorneys try to do as well. So this is a fairly new field. Jury consulting is a fairly new field. And as far as I'm aware, they haven't come out with official ethical guidelines at this point. But these are some of the things to keep in mind when you think about jury consulting. Now I just wanted to kind of show you a short video that explains some of the benefits of having a jury consultant and kind of some of the things that jury consultants really do.
Hi, I'm Dr. Thomas Baggett, and I'm the founder of the Jury Behavior Research Corporation. I'd like to tell you why we are different than the other trial consulting agencies. First of all of our consultants hold doctoral degrees in behavioral science fields. Among us, we have more than 50 years experience in and out of the courtroom working within the legal system. We follow a stringent code of ethics, and we have a strict scientific protocol for all of our pretrial research. On the day of the research itself, before even beginning with evidence, we establish a baseline with our jurors by having them predict how they think they will find at the end of the day. We have found that it's important to know how much effect geography and demographics have on your probable outcome. We take extensive measurements throughout the day so that we can tell you not just what the verdict was, but why that particular verdict was found. We take extensive measurements so we can examine the cognitions of individual jurors and the jurors as a group to tell you where your case was strong and where your case was weak. We employ safeguards to assure that we measure evidence and not just attorney skills. We evaluate attorneys in 7 different categories so that in the end we can determine whether it was the force of one attorney that overpowered the other or whether we actually measured evidence. At the conclusion of the on-site part of the research project, we examine the data and recommend modifications to improve your position prior to trial. We are able to forecast the probable outcome of the case if it is presented unchanged. If liability is found, we can give you an accurate estimate of the high and low of what the damages will probably be. Lastly, after we're done with the on-site part of the research project, we examine all of the data, including the written comments by all the jurors made throughout the day. We're able to determine what was important to the jurors, what changed their minds, what made them find the way that they did. We then use this information to help you develop trial strategies to maximize your outcome. At Jury Behavior Research, we're very proud of our return rate of clients. They come back to us over and over because of the value.
So that kind of, gives you a little bit of an idea of what these consultants really do. So they may actually run the trial with another sample of people, so this mock jury, and also figure out where the case might be weak and make suggestions on how to improve that. Another thing that jury consultants do is jury selection. So I just wanted to show you another little short video about jury selection and what happens during this process.
All right, I'd like to walk you through the jury selection process, or as I like to call it, the jury rejection process, because when you're choosing a jury, you're not actually picking jurors, you're eliminating them, you're rejecting jurors. So let's walk through the process, and every court, every judge does it a little bit differently. In this case, the first thing the potential jurors had to do was fill out a jury questionnaire. Very common in high-profile cases to have all the potential jurors, the 500, fill one of these out so the lawyers get an idea of where these jurors stand on some issues. Then it's time for voir dire. Voir dire, to speak the truth. And the first part of this voir dire is taking place now, which is pretrial publicity. How have these jurors been impacted by what they've seen or heard in the media, in the newspaper, social media, from their friends, wherever? The pre-trial publicity, has it impacted their ability to sit as jurors in this case? Then Another round of voir dire where they get more general questions in the general voir dire, where they're asked other things so these lawyers get a better idea of who these potential jurors actually are and what they are thinking. Then once the lawyers gather all this information, it's time to strike the jury, to eliminate jurors. Not pick them, but eliminate them. And they can be eliminated two different ways. One, challenges for cause. And these are general reasons, like they can't put aside what they've heard about the case. They can't be fair and impartial. They've got 15 kids at home and they don't have any child care. All these reasons that they can be stricken for cause. Now, the second way jurors get eliminated are the peremptory challenges. Each side in this case gets 10. And what a peremptory challenge is, you can eliminate any juror for any reason or no reason at all, except race. And finally, once they strike all these jurors and whittle them down, our juror will end up as one of 6 who will listen to the case, not 12, but 6 jurors with 2 to 4 alternates sitting in judgment of George Zimmerman.
Okay, so that clip there kind of was very specific to a certain case that was being talked about. So, the 6 jurors versus 12 isn't always true. But the main idea that I wanted you to get out of that was just kind of what jury selection is. So jury selection isn't actually picking jurors. Jury selection is weeding out jurors or removing potential jurors that are biased. And as you saw in the video there, that can be done through something like a juror questionnaire. So a juror questionnaire is something that jury consultants would help create. They would help come up with the questions that are going to elicit the responses in order to determine factors that might influence whether or not a potential juror is biased in the particular case. They can also influence the way in which voir dire questions are asked. Although that will be the actual attorney asking those questions, they will assist with that. Or they might, as you heard in the video, they talked about pretrial publicity. So jury consultants might have a lot of research on PTP and influence or educate the attorneys about how that might be influencing their case, and so on and so forth. So the main idea there is to get that jury selection is actually not selection. Jury selection is removing individuals from this bigger potential pool of jurors, and that's how you arrive at the actual jury that will be used in a certain case. So as you can see there, yes, it's a process of elimination rather than selection. So overall, I hope this gives you an idea of what jury consultants do. And as you might guess, the salary for jury consultants is quite high. It can be anywhere from $150,000 to $600,000 a year. So it is a very well-paying job. Okay, so I've just, given you a taste of what the different roles are that psychologists can play in the legal system, and I will see you next time.